Good morning and welcome to another episode of GSL, our interactive broadcast coming to you live from the studio at Gough Square Chambers. My name is Crowe and I will be your host this morning along with my colleague Michael Coley. Today we will be presenting on the lessons that arise out of the recent Supreme Court decision in the case of R&C and others, a decision relating to the proper construction of the Section 92 offence under the Trademarks Act, namely unauthorised use of trademark. We'll be grappling with the big questions considered, including what sort of goods are caught by the offence, is the way in which the goods were manufactured important, and is the scope of the Section 92 offence extended by this case. There can be no doubt this episode is a thriller. Anyway, by now I hope you're all familiar with the interactive process, but for any newcomers or indeed those slow on the uptake, you are able to ask questions as we go via Google Chat on the YouTube site if you have an account, or simply by pinging us an email and we'll attempt to deal with it at the end. So without further ado, over to our main speaker today, Michael.
Thank you, Cameron. Today we're going to be looking at the case of C and others, as you've heard, which is a recent Supreme Court decision concerning the status of grey market goods in prosecutions under Section 92 of the Trademarks Act 1994. Now, although it's a Supreme Court decision, it's actually a case which is still awaiting trial, because the question which the Supreme Court had to consider arose as a preliminary matter, and the prosecution, which was in the Crown Court, was stayed pending the appeal to the Court of Appeal and then onwards to the Supreme Court. Factually, the case concerns a limited company and two individuals connected with the running of that company. So they are the three appellants, or defendants, in the Crown Court. They were alleged to have been involved in the bulk importation of items including clothing and shoes. And the trademarks involved included brands such as Ralph Lauren, Adidas, Under Armour, Jack Wills and Fred Perry. Now, some of those items were manufactured without the trademark owner's consent, and they are referred to in the judgment as true counterfeits. Others, however, were initially manufactured with the consent of the trademark owners, but were then sold without their consent, and those are the so-called grey market goods. Now, the issue that's raised in the case of C concerns those grey market goods. So we're not talking here about what the Supreme Court described as true counterfeits, counterfeits which were fake from the very beginning. We're talking here about goods which are, for example, overruns, where a factory produces extra examples in case some end up being damaged, items that don't meet quality control standards, or situations where the trademark owner has outsourced manufacturing under license, and the license comes to an end and the contractor puts the outstanding items on the market without the trademark owner's consent. Now, in the case of C, what the appellant sought to argue was that sections 92(1)(b and 92(1)(c of the Trademarks Act applied only to goods which were true counterfeits, and that where a prosecution under those sections concerned goods which were merely grey market goods, those goods would fall outside of the offences. The appellants raised two arguments in support of that proposition, and if we have a look at slide 1, we can see how those two arguments were framed in brief. So as you can see, the two arguments were that, covered by the first two bullet points, the term such a sign, which appears in paragraph B and refers to a sign identical to or likely to be mistaken for a trademark, should, as a matter of statutory construction, be interpreted as only referring to signs which have been applied to an item without the consent of the trademark owner, and that would have the effect that grey market goods would be distinguished from true counterfeits and not caught by the offences. Secondly, and alternatively, the appellants argued that interpreting paragraphs B and C so as to include grey market goods infringed the protection against interference with property set out in Article 1 of Protocol 1 of the ECHR. So, how did the Supreme Court determine those issues? Well, in fact, their approach to the question was largely one of traditional statutory interpretation. And if we can put slide 2 up, we can see the full text of the provision that they were being asked to interpret. So what you see at the moment is section 92, subsection 1 of the Trademarks Act. And what we can see towards the top of the slide is that the key issue here is that consent of the owner of the trademark is the important thing. But it's important to note that the issue of consent is referred to not under paragraphs A, B or C, but under that main part of subsection 1. So subsection 1 provides a set of common elements which apply equally to each of those offences under paragraphs A, B and C. Now importantly, the Supreme Court held that those offences at paragraphs A, B and C are all separate and distinct. They're not cumulative. And that means that each of those paragraphs sets out a different action which requires the consent of the trademark owner in order to be done lawfully. So under paragraph A, the action is applying a sign which is identical to or likely to be mistaken for a trademark to an item. Under paragraph B, it's selling an item which has such a sign on it. Under paragraph C, it's possessing such an item with a view to selling it. So the three acts, broadly speaking, to which the consent attaches are the acts of applying, selling, and possessing. So the next question, of course, is in paragraphs B and C, what is it that you have to sell or possess? And the answer the Supreme Court arrived at is that you're selling or possessing an item which has what the legislation describes as such a sign applied to it. Now, what the defence tried to argue was that the term such a sign means a sign which has been applied without the consent of the trademark owner. Now, the Supreme Court rejected that submission. They said that the term such a sign referred back to the description in paragraph A of a sign identical to or likely to be mistaken for a trademark. And that was simply a description of the sign. The court held that the consent attaching to the application of the sign to the item is only relevant to paragraph A, and that's a completely separate offence. If Parliament had intended for the effect contended for by the appellants, paragraphs B and C wouldn't just use the phrase such a sign, but would say something along the lines of such a sign so applied. And they set that out at paragraph 12 of the judgment, where they say the appellant's reading of paragraph B is strained and unnatural. It does not simply reach back to A, but to the general words of the section which precede it. It requires one to read the word sign in A, which is incorporated into paragraph B, as which bears a sign so applied, or at least such a sign so applied. So what this means is the court held that what's required for guilt is that the act of selling or possessing was done without the consent of the trademark holder, and what had to be sold or possessed was an item which bore a sign identical to or likely to be mistaken for a trademark. That item could well be a true counterfeit, but it could equally be a genuine item or overrun or any of the other types of grey market goods, because those too are items which have a sign identical to a trademark applied to them. Consequently, the court concluded, on the basis of the ordinary principles of statutory interpretation, that grey market goods therefore do indeed fall within the ambit of paragraphs B and C. So next, the court turned to deal with the defence submissions on Article 1 of Protocol 1. And if we look at slide 3, we can see what that article says. Now, Article 1 is concerned with the protection of private property, and in the case of Sporren and Longroth in Sweden, the European Court of Human Rights indicated that it contains 3 distinct rules. First of all, there's the general principle of peaceful enjoyment of property, which is contained in the first part of paragraph 1. Secondly, there's the rule that any deprivation of possessions should be subject to the conditions in the second part of paragraph 1. And finally, the principle in paragraph 2 says that states are entitled to control the use of property in accordance with the general interest by enforcing such laws as they deem necessary for the purpose. Now, in relation to Article 1, the court held that the appellants had no proprietary right in the trademarks, so there's nothing for Article 1 to protect in that respect. They did have rights in the goods which they bought. However, the Trademarks Act doesn't stop them from selling the goods, it just requires they're not sold with the infringing trademarks attached. And what the court said at paragraph 19 of its judgment was this: the 1994 Act does not therefore deprive the defendants of any property which they have. The most it does is to regulate their use or the manner of their disposal of the goods, which is permitted under the second paragraph of Article 1 in the general interest, which must include a general interest in the protection of trademarks. So they concluded that there was therefore nothing disproportionate about penalising infringing sales of grey market goods with a criminal sanction. and they described Section 92, subsection 1 of the Trademarks Act as a perfectly legitimate balance to draw between the rights of the proprietor to protect his valuable trademark and goodwill, and those of the person who wishes to sell goods which he has bought. And it's actually in its conclusion on interpretation, at paragraph 18 of the judgment, that the court, in my view, neatly sums up the real issue in the case from a policy perspective, augmenting its application of the literal rule of statutory interpretation with the mischief rule. And we can see exactly what they said on slide 4. And the paragraph that you see at the moment, in my view, neatly sums up the judgment. In the first part, the court quickly scotches the notion that there should be any distinction drawn between grey market goods and true counterfeits from the perspective of consumer protection. The grey market goods often are kept off the market for good reason. They cite the fact that often they might be defective, for example. In the second part of that paragraph, the court addresses the issue of protecting the trademark holders. And they say very clearly, defendants who set out to buy up grey market goods to make a profit on resale do so because the object is to cash in on someone else's trademark, and if such be proved, they have scant claim to a beneficent construction of the act. So what does this mean for people who prosecute offences like these? Well, in my view, this judgment is not a particularly groundbreaking one. The Supreme Court has looked at the legislation, they've read it through line by line, they've come to an entirely sensible and, in my opinion, predictable conclusion. And Cameron and I have prosecuted many cases such as this. In my experience, on more than one occasion where the defence has been, it's not a true counterfeit, I've taken the Crown Court through exactly the exercise the Supreme Court has gone through, with exactly the same result. So on one level, what the Supreme Court has done hasn't really shown us anything that wasn't already in the statute. But what it has done is finally brought some senior court authority to bear on the question, which should hopefully avoid advocates having to go through that exercise in future. Because as straightforward as it actually is, once you get to grips with it, it is rather tedious. It also deals with and dismisses some of the extraneous sources which the appellant sought to use in support of their arguments, and it provides a reasoned basis for its interpretation of the section. For training standards officers, it also arguably doesn't change a great deal, but it does act as a reminder that simply saying, "I thought the goods were genuine," won't necessarily be enough to discharge the burden of proof on the defendant if he wishes to raise the defence under subsection 5. What follows from the decision in C is a genuine item in the sense that it was manufactured with the consent of the trademark holder, if sold or possessed without the consent of the trademark holder, is still an infringing item. So if a defendant wishes to raise a subsection 5 defence, he must not only establish that he believed on reasonable grounds that the item was genuine, but also that he believed on reasonable grounds that he had the trademark owner's consent to sell it or possess it for sale. And that's something which those investigating this sort of offence should be aware of and should deal with in interview. And finally, it should be noted that this is not a case which dealt on point with the issue of parallel imports. The Supreme Court was silent on how the issues raised in the appeal operate in respect specifically of parallel imports, and doesn't appear to have been required to consider the judgment. So this is a judgment restricted to goods where there is no consent by the trademark owners for them to be put on any market at all. So the Supreme Court has decided that there are definitely no shades of grey when it comes to grey market goods. They unequivocally fall within paragraphs B and C of section 92.1, and as things stand currently, the case has been remitted to the Crown Court for the prosecution to resume.
Well, thanks, Michael. We're moving now to questions in a moment. I'll apologise beforehand. Apparently there's something of an echo on today's broadcast. So, Michael, why is there an echo on today's broadcast? That's the first question. We have been having we had a sound issue with the last one. We thought we had resolved that, but clearly not. Aha! It's gone now. It's gone. It's gone now. Did you do something? Richard did something.
Richard has sorted it.
We have found the problem. It was Richard. Richard has now sorted it. So now on to the more substantive questions. It's been very quiet on the chat, save for the echo. But we have this. What is the practical difference between so-called grey market goods and parallel imports, as they are terms often used interchangeably?
Yes, well, the key difference between grey market goods and parallel imports is that in the case of parallel imports, what we're talking about strictly is goods which are placed on a market with the consent of the trademark holder, but are then imported into another market without that consent. And for the purposes of parallel imports, the European Economic Area is considered one single market. So a parallel import will be a good which a trademark owner puts onto the market in, say, Australia, and is then imported into an EEA territory. Grey market goods, such as those which this case dealt with, are goods where there is no consent whatsoever by the trademark owner for them to be placed on any market.
For sale at all?
For sale at all, yes.
There's then a follow-up question, which is, what if the genuinely manufactured goods had been authorised for sale, but only in one region, and then shipped to another region for sale without the consent of the trademark holder, which is something that you've just touched on?
Yes.
What difference does that make as far as a potential prosecution of a Section 92 offence is concerned?
Well, the way that EU law regulates parallel imports is, as I said, to treat the EEA as a single market. Anything which is placed onto a market outside of the EEA would therefore require the consent of the trademark holder if it were to be sold anywhere in the EEA. And so theoretically, that means that if someone were to import from a different market, sales within the EEA would be without the consent of the trademark holder and would arguably fall within Section 92. However, you have to consider that what the public interest test would be, because when it comes to goods which are not authorised to be put on any market at all, it may be because they're defective or because they are in some ways detrimental to the consumer, which arguably might not be the case for a good which is lawfully on sale to consumers in another market.
I think I'd add to that in two ways. The first is that there's some quite complex intellectual property law that underpins that, to do with the exhaustion and non-exhaustion of IP rights in international and regional markets. What you need to be considering, whether as a public or a private enforcer for the purposes of a Section 92 criminal prosecution, is not only the elements of the offence, but, as Michael says, the public interest test. Are you really likely to be bringing a Section 92 offence in relation to what appear on the face of it, at least, to be perfectly legal, legitimate goods that were placed on sale, for instance, in one region and are identical to the goods that would be placed on sale in this region? Answer, almost certainly, I hope not. If there are differences between the goods, though, even if they are legitimate, even if they're considered parallel imports in the truest sense, you could potentially consider an alternative approach. If a consumer's been misled, for instance, and that misleading has in any way impacted on their transactional decision making, you could also be considering offences under consumer protection from unfair trading regulations. So it's going to require a factual analysis of the circumstances of the goods and a proper consideration of the prosecutorial threshold tests, in my view. Agreed?
I'd agree, yes.
I'm pleased to hear it. As indeed I'm sure the Supreme Court were to hear you say that you thought their judgment was sensible. We have another question. It's sort of related. In the case of, for example, possession of grey goods for sale in the course of a business, etc., what sort of inquiries, checks would need to be made to satisfy the court or jury that the statutory defence under subsection 5 is made out?
Yes, well, this comes back to the point which we raised earlier about defendants often simply saying it's not a counterfeit good and leaving it at that. They have to go a step further, I would suggest, in order to establish that the goods were actually authorised for sale in the market in which they're seeking to sell them. Now, that would entail, for example, making inquiries of the people from whom they bought them, making checks into the provenance of those goods, and effectively making sure that where they come from is where they ought to come from. Quite often, simply asking the person you bought them from, "Am I allowed to sell these goods?" is probably not going to be enough to establish the threshold for the defence, because clearly someone who's illicitly trying to sell those goods is hardly going to be honest about it. But it's going to involve trying to obtain enough evidence about the provenance of the goods to put before investigators to be able to say that they do amount to reasonable grounds for believing not only that the goods were genuine, but also that the way in which the trader has come by them makes them non-infringing, in the sense that either there is no need for consent because intellectual property rights have been exhausted, or that the person selling them those goods had some sort of authorization by the IP rights holder. And where we're talking about an official distributor, there'll often be paperwork. And so simply saying to them, well, where's your paperwork that authorizes you to distribute these goods in the EEA or in the UK, would be, in my view, a reasonable question to ask. And the failure of a seller to the trader to produce that paperwork I would suggest, put them on notice pretty quickly.
I think it's a good question, and it raises the fact that the Supreme Court decision is essentially one on principle in the circumstances of the case. The factual background is yet to be determined, and it will be interesting to see how it ultimately is determined, because one can see a pretty decent argument, not necessarily on the precise facts of this case, but where a trader says, well, I went to the factory, they were clearly an authorized factory, manufacturing authorized goods. I spoke to the head of that factory, I saw paperwork, and having seen that paperwork, was satisfied that the goods I was then going to receive were going to be legitimate. Then not knowing that in fact the goods that they ultimately received were out the back door and weren't the ones that were authorized for sale in any particular region. So in those circumstances, you'd probably argue that they'd satisfied the reasonable grounds for believing tests, yes, to avail themselves of the statutory defence. So I think it will be interesting to see what happens. And as investigators and prosecutors, whether public or private bodies, it will be important to make sure you have considered those questions when considering whether the public interest and the threshold test is met for the purposes of bringing a prosecution. There's one other question, which for me is it's a difficult one, so I'm going to give it to you, Michael. Fred from Hertfordshire asks, isn't this judgment anti-consumer and simply propping up the prices for brands?
Well, I think that there are 3 points which arise out of that question, really. The first is that what the Supreme Court has done is simply interpreted the provisions in Section 92 as they're drafted. The question of whether those provisions are appropriate or safeguard the rights of consumers generally is really one for Parliament, and I think that to go much further would have been a fairly activist course for the Supreme Court to take. But secondly, the Trademarks Act is a strange creature in that it is not only there for the protection of consumers, but it's also there for the protection of the trademark holders. And unlike some pieces of consumer legislation, where it's sometimes there is a tension between the interests of consumers and businesses, this is one which seeks to protect both of them at the expense of counterfeiters and importers who would seek to undermine that. And I think that one of the things that the Supreme Court said in their judgment is very pertinent to that question, because certain grey market goods are kept off the market by the trademark holders, not just in order to control price and supply, but because the quality is poor, and in the case of some of them, they may even be dangerous, if you're looking at things like consumer electronics, for example. And so it's not simply the case that allowing consumers to buy grey market goods would protect their rights regarding pricing. It may well do that at the expense of their rights regarding safety. But the third point is that alongside the consumer protection issue is that the brand protection issue, and that when it comes to pricing, the way the market should deal with it is that brands in the market are entitled to set their prices, competitors set theirs, and if a brand's pricing is too high, it either lowers it to compete or it increases the quality in order to justify it. And it's quite right that pricing pressure is regulated by competition with your other suppliers and your competitors. That's a different thing entirely, though, from pricing pressure being influenced by competitors who are not legitimately in the market, but who are placing a brand's products on the market illicitly. And I think the Trademarks Act does need to protect, to some degree at least, the autonomy of the trademark holders to be able to decide how and where and for how much their products are to be sold. And so that's the balance, I think, that the legislation certainly needs to strike. But in terms of the decision, I don't think it could have done very much more than simply interpret the provisions as drafted.
Let's see, an interesting answer. I wouldn't have answered it that way because I'm not that bright, but I'd have simply said that seems to me to be a question for the politicians rather than for the lawyers and the courts, who must simply interpret and apply the law as it is. We do have a few more that have come in. A good one from Alexis, as a trading standards enforcer, and it's very similar to a question from Green Rider as well. As a trading standards enforcer, are we likely to need to request that trademark holders include a paragraph, presumably in statements, emphasising permission was granted for application of the trademark and possession at that time, but not for sale?
I think it's going to depend on the facts of the case. Many cases where you get a statement from a trademark holder, the initial examination simply reveals that the item is counterfeit, and it's left at that. If it's counterfeit, then there's certainly no permission for sale or for anything else. If the initial examination goes beyond that, and we have a situation where the trademark holder says, well, actually, this is one of ours, but we didn't intend for it to be sold in this market or indeed at all, then yes, you would need evidence from the trademark holder setting that out and setting out what the permission was and what its intention was in relation to the goods. So something, for example, saying these goods are ours, but the quality would not meet our quality control procedures, and so they would never have been released for sale onto the market, and they were intended to be destroyed. Something along those lines would set out the lack of permission for onward possession or possession for sale.
Here's the final question. There is a very fact-specific one. I could argue, if there's a struggle here, that it's not in fact a question and is more a statement. But it says, therefore, and it's from Tim, a charity shop could not sell genuine goods in the UK that were donated by postal service as unclaimed post for items destined for abroad.
That is an interesting one.
It is. It's a statement, though, so we don't have to answer it. I'd have to think about that one, frankly, and do some considerable analysis as to precisely the nature of the goods, although they say they're genuine goods in the UK. True. He's added the question. True? Question mark.
Well, I mean, arguably, if you have a trademark holder who's put the goods on for sale outside of the EEA, and someone in that jurisdiction decides they want to post it to a charity shop in the UK for the charity shop to sell.
No, but that's not the question. No. There's genuine goods in the UK.
Oh, in the UK.
Destined for abroad. You'd have to look at the IP rights that underpin it in relation to that particular product.
I think so. I think they'd be okay because actually the sale is within the jurisdiction. It's within the market. And then presumably someone who wanted to send it to a friend abroad isn't putting it on sale in the third market. But yeah, I think it could be a very fact-specific issue. And I think in the context of that particular set of facts, the public interest test is also going to very clearly apply.
Yeah, undoubtedly. That appears to have exhausted our questions. Nothing else on the email. Nothing else on the chat. Anything from the live audience? No. Okay. Well, there we are. Thank you all for listening. I hope it's been helpful and informative. The next talk is on the 14th of September, 11 a.m, when Alison Lambert and Robin Kingham will be discussing changes to the primary authority scheme due to be introduced from the 1st of October. So they'll be dealing with issues such as the nature of the partnership moving forward, whether there is truly simpler access and the streamlining of the system. I hope you tune in for that. I hope you find that one informative. But for the time being, it's goodbye from me.
And it's goodbye from me.
Goodbye.